Imagine this. You walk into your gym, ready for a workout, and you see two signs right next to each other.
Okay.
One says, all members must show membership cards and photo IDs to gain entrance. Pretty clear.
Standard stuff.
But then right behind it, kind of less obvious, another sign declares, members no longer need to show cards and IDs.
Huh. Confusing.
Totally confusing, right? And then you just swipe your finger and you're in. So what's actually going on there?
Yeah, what rule are you following?
Exactly. Well, that little everyday moment of perplexity is actually our way into a much bigger, really fascinating, and honestly essential concept we call legal pluralism.
Mm-hmm.
Today, we're taking a deep dive into the sources to understand how multiple sets of laws and legal practices operate. Sometimes they work together, sometimes they're in direct conflict, all at the same time, in the same place.
Yes.
It's kind of your shortcut to understanding these invisible legal forces shaping your world, often in, well, surprising ways.
Yeah. That's right. And our mission here in this deep dive is really to go beyond just, simple definitions.
Okay.
We'll explore the different layers of law, from the super local, like your gym, right up to the global, the supranational level.
Wow.
We'll look at how they interact, how they create sometimes unexpected outcomes, and how they reveal this really complex fabric of social control.
Okay.
So you'll hopefully gain a richer understanding of not just what these laws are, but really why they matter and what implications they hold for our daily lives. It gives you a powerful lens, really, to view the world.
Okay, so let's kick things off by going back to that gym scenario. Our sources describe it perfectly. You had the corporate policy demanding IDs.
Right, the top-down rule.
But the local gym had just installed this new fingerprint scanning system, Practical.
Mm-hmm. The local reality.
So the staff's solution, just post both signs.
Yeah.
Knowing full well the local fingerprint system effectively made the corporate ID rule, well, pointless in practice.
Yeah, they just ignored the conflict in a way.
That's a pretty clear example of two rules at odds, isn't it?
It is. And that brings us directly to legal pluralism. Formally, it's the existence of two or more sets of laws and legal practices operating simultaneously in the same place.
Right.
But it's not always about direct conflict like the signs.
Yeah.
Often these layers just coexist, or they actually complement each other.
Okay, yeah. I mean, for many of us, especially, say, in the United States, the most familiar example is probably our own system, right? Federal, state, local laws.
Exactly.
Think about taxes. You've got your federal income tax, then, most states have their own state income tax, and then you often have local property taxes.
Right. They're incremental, they're layered, and they're mostly complementary. Each level kind of has its own job.
Each jurisdiction has its own responsibilities. Makes sense.
Precisely. Or think about federal agencies like OSHA, that's the Occupational Safety and Health Administration. They oversee workplace conditions nationally.
Right.
But many states have their own parallel workplace safety agencies too. And how their responsibilities mesh. Well, that's typically worked out through tons of technical guidelines and just customary practices. It shows a kind of cooperative pluralism.
So multiple rules, but structured to work together, mostly.
Mostly, yeah. And we can differentiate between these nested or complementary systems, like, say, minimum wage laws. The federal government sets a floor.
Like $7.25 an hour back in 2015, I think the source said.
Right, exactly. But states and cities, they can set higher wages. California was $9 then. San Francisco even higher at $12.25.
So that's adding on, not contradicting.
Exactly. It's an addition. What the gym signs show, though, is a contradictory system where rules directly oppose each other in practice, even if both are still technically on the books.
Right. And that really shifts the dynamic, doesn't it? When these systems aren't complementary, when they actually clash.
Mm-hmm.
What's the immediate fallout? How does that usually play out for people caught in the middle?
Well, often one system tries to assert dominance. Take immigration law, for example.
Mm-hmm.
We've seen states and cities pass laws trying to, say, prevent renting housing to or even schooling children of undocumented immigrants.
Right. I remember those cases.
But these laws are frequently challenged in court, and sometimes they're voided entirely. Why? Because immigration law is constitutionally the sole prerogative, the sole responsibility of the federal government.
So the federal level trumps the state level there.
Effectively, yes. The state's efforts get nullified by the higher authority. So individuals caught in this find their local protections or restrictions suddenly just vanish.
Okay, that's a pretty clear federal override. But what about when it's not so, clean cut?
Right.
When the conflict just simmers?
Good question. Consider California's Proposition 209 back in 1996.
Okay.
Voters there amended the state constitution to prohibit discrimination based on race, sex, or ethnicity in public institutions. Now, the stated goal was ending discrimination.
But the practical effect was ending affirmative action.
Essentially, yes. And this immediately ran into conflict with federal equal protection standards, which in some situations actually endorse proactive programs for historically excluded groups.
So what happened? Did Prop 209 get struck down?
Well, it largely survived the legal challenges. But California's public higher education institutions, which rely heavily on federal funding, they still struggle constantly to reconcile this state constitutional ban with federal mandates for outreach and diversity.
Ah, so it's not an outright nullification like the immigration example. It's more like a persistent, messy struggle.
Exactly. They can't just ignore the conflict like the gym staff could. They're caught between two powerful legal directives. It's an ongoing tension.
Okay, I see.
Then there's medical marijuana, another classic example.
Right.
California voters permitted its cultivation and use when prescribed by a doctor. State law says okay.
But federal law?
Federal law still criminalizes it completely.
So you have direct conflict.
Direct conflict. And this has led to federal indictments, federal prosecutions in California for activity that's legal under state law.
Wow.
And the U.S. Supreme Court actually upheld the federal DEA's right to enforce federal laws, even in states that legalized medical use.
So in that case, you have two separate and conflicting laws operating side by side, neither one fully voiding the other in its own sphere.
Precisely. It creates this incredibly high-stakes legal tightrope for growers, dispensaries, patients, anyone involved.
Okay, so we see federal authority overriding local rules, or creating this kind of persistent tension. But sometimes this layering of law doesn't lead to a clear override or even just tension, but to something, well, much messier. Something one scholar, Frank Zimmering, called a Frankenstein's monster when talking about the death penalty in the U.S.
That's a perfect, if grim, description.
Yeah.
Before 1972, state criminal law, including the death penalty, was basically exclusively the province of state governments.
Right, states decided.
But then a huge Supreme Court case, Furman v. Georgia, changed everything. The court found that the vast variability, the sheer randomness sometimes, in how states applied the death penalty, violated the Eighth Amendment's prohibition against cruel and unusual punishment.
Okay, so the Supreme Court stepped in.
Right. And by 1976, when the court started approving new state death penalty laws that states had rewritten, it implicitly established a set of federal standards, or at least federal oversight. It created this new, layered legal landscape for capital punishment.
So you'd think this federal oversight would lead to more consistency across states, right? Less variability.
That would be the logical assumption. But the sources, particularly Zimmering's work, highlight the exact opposite happens.
Really? How so?
State variability was not reduced. In fact, you could argue it became entrenched in a different way. So while 12 states now have no death penalty at all, and another 7 have it on the books but effectively don't use it, a very small handful of states, and 88% of those executions happen in the American South, are responsible for the vast majority of actual executions carried out.
Wait, so the concentration of executions in certain states, mainly the South, is actually greater now than it was before the Supreme Court tried to make it more consistent.
That's what Zimmering found. It's this bizarre, unintended consequence of layering federal standards onto existing state systems.
Wow. And the appeals process only adds to this complexity, I gather.
Oh, absolutely. It's incredibly complex. A typical capital trial starts in state court. If there's a conviction and death sentence, it goes through state appellate appeals.
Okay, standard state process.
Right. But only after all those state appeals are completely exhausted, which can take years, can the defendant then file what's known as a writ of habeas corpus in a federal district court.
And that's the mechanism allowing someone to challenge their detention in federal court, right, after the state process is done.
Exactly. It's a federal review of the state conviction and sentence.
Yep.
But this whole process, state plus federal, often takes well over a decade.
A decade.
Which is precisely the irony Zimmering points out. The federal review is last in line. It comes at the very end.
Yeah.
And that's where a lot of the public frustration and resentment about delays gets focused. Why is this taking so long?
Right. People blame the federal courts.
But that federal stage is actually the most critical stage for applying these supposed national standards, for acting as a quality control on what happened in the state courts.
Ah, I see the irony.
So the whole system, with its multiple layers, disconnected timelines, and conflicting pressures, is, as Zimmering concludes, profoundly dysfunctional. It's a legal morass created by this specific form of legal pluralism rather than a clear, unified system.
Okay, that's a really powerful example of dysfunction. Now, beyond these sort of explicit layers, federal, state, local governments, there's another vast and really powerful realm, administrative law. This is where, for many people, the law really hits the road, right?
It truly is. Administrative law basically refers to the legal order that establishes, interprets, and implements the rules of administrative agencies.
Right.
Think the Social Security Administration or Immigration and Customs Enforcement, ICE.
Okay, government agencies making rules and decisions.
Exactly. And it's a prime example of legal pluralism because it's often highly decentralized. The adjudicators, the administrative law judges, or officers making decisions often have substantial discretion, a lot of leeway.
Right.
And what's more, crucially, they often aren't institutionally independent of the very agencies whose actions they're reviewing.
Wait, so the judge works for the agency they're judging?
Often, yes, or within the same overarching department. This structure, combined with discretion, leads to potentially enormous disparity in outcomes.
Yeah.
Huge differences in decisions.
So these are government bodies with their own rules, but they operate almost like mini legal systems within the larger government structure.
That's a good way to put it, precisely. One really extensive study looked at disability claims within the Social Security Administration, the SSA. It's described in the source as the largest system of administrative adjudication in the Western world. Just a massive caseload, millions of urgent appeals affecting people's livelihoods.
Yeah, huge impact.
And the study found that decisions were vastly disparate. Often it seemed to come down to the individual proclivity, the personal views or work habits of the specific administrative law judge handling the case.
And these judges are SSA employees themselves.
Yes, which creates at least the appearance of, if not an actual structural bias. It's a profoundly pluralistic system in practice, driven by individual discretion within this massive bureaucracy.
Wow.
And maybe even more striking are the, quote, eye-popping disparities found in studies of asylum decision-making. This area is sometimes called refugee roulette for a reason.
Refugee roulette. That sounds grim.
It reflects the perceived randomness. The process is complex, often 4 tiers. First, an asylum officer, then, if denied, an immigration judge, then appeal to the Board of Immigration Appeals, the BIA, and potentially then to a federal circuit court.
Okay, lots of steps.
And at several of these steps, especially with the immigration judges, there's huge discretion. The studies found massive discrepancies. For example, some data showed Chinese asylum applicants whose cases were heard in Atlanta, Georgia, had only a 7% success rate.
Only 7%.
But similar applicants whose cases were heard just a few hours away in Orlando, Florida, had a 76% success rate.
7 versus 76. That's unbelievable. It's the same law, presumably.
Same law, same country of origin, potentially similar facts, but vastly different outcomes depending on where the case was heard and likely which judge heard it.
So it really depends on the individual adjudicator.
Their individual preferences and attitudes seem to play a huge role, yes. But it's not just individual whim. It's also influenced by what scholars call the strategic model of judging. Meaning institutional factors, structural pressures, and even political signals influence decisions.
Ah, okay. Can you give an example?
Yes, a key one mentioned is from 2002. Then Attorney General John Ashcroft issued orders aimed at streamlining decisions by the Board of Immigration Appeals, the BIA.
Streamlining how?
Mainly by drastically reducing the number of cases heard by 3-member panels and increasing the number decided by just a single BIA member.
Okay, efficiency measure maybe?
That was the stated goal. But what happened? Favorable asylum decisions granting asylum declined significantly in every region across the country afterward.
Why? Because single judges are tougher.
Studies suggest single BIA members tend to have lower grant rates than 3-member panels on average. So changing the structure altered the outcomes. But it also likely sent an implicit political message down the chain, a signal about the desired direction of decisions.
So an internal policy shift within an agency created a whole new layer of legal reality for asylum seekers.
Exactly. It demonstrates how these administrative systems, with their lack of independence and susceptibility to internal pressures, generate pronounced plurality in outcomes. It's legal pluralism in action within the bureaucracy itself.
Okay. Now, it's not just government, right? You mentioned earlier this concept extends beyond public institutions. It touches private realms, even global stages.
Absolutely. We see this quite clearly with the rise of private security firms, ubiquitous surveillance systems, neighborhood associations. They all add their own layer of rules, sometimes quite potent law-like fiats.
Right.
And in some cases, like with private prisons, public and private jurisdictions become functionally intertwined, blurring the lines of authority and accountability. It can create powerful and sometimes, frankly, unsettling dynamics.
And sometimes this pluralism, this mix of public and private rules, creates a kind of dangerous legal limbo, doesn't it? Where accountability just falls through the cracks.
It absolutely can. One critical example the sources discuss is Blackwater Worldwide, the private military contractor.
Ah, yes, in Iraq.
Exactly.
Yeah.
Contracted by the U.S. State Department in Iraq, their rules of engagement were notoriously vague. They weren't subject to military regulations like soldiers were.
Okay.
They're also explicitly exempt from Iraqi law
Okay.
under the Coalition Provisional Authority orders at the time.
Yeah.
That was the huge question. They sometimes appeared to skirt all accountability, even some U.S. laws that might apply to other American civilians working abroad. This partial legal limbo became starkly evident in incidents like dropping riot control gas from helicopters or, most infamously, firing on unarmed Iraqi civilians in Nicer Square.
Right.
It raised profound questions about jurisdiction, oversight, and who ultimately held authority when these private actors operated in this gray zone between different legal orders.
That's a really stark example of how overlapping or maybe non-overlapping legal systems can lead to accountability gaps. On a much more everyday level, though, what about homeowners associations, HOAs? You mentioned them. They've become incredibly common.
Incredibly common. The sources cite figures from just 500 in 1965 to over 230,000 by 2007 in the U.S. alone.
Wow, that's explosive growth.
It is. And often, HOAs step in to provide services like landscaping or security when local government funds are scarce. They operate as these quasi-corporate entities, almost like mini-governments.
Mini-governments with their own rules.
Oh, yes. Setting fees, issuing directives on everything from the color you can paint your house to how long your garage door can be open to prohibiting drying laundry outside or repairing your car on your own property.
They can be quite restrictive.
They can be. The sources mentioned one particularly notorious case. I think it was Fountain Valley Chateau Blanc Hometowners Association v. Department of Veterans Affairs.
Okay.
Where an HOA repeatedly reprimanded an elderly man who had Hodgkin's disease for sloppy housekeeping. They actually ordered him to clear books and papers from his bed and floor.
Seriously, inside his own home.
Inside his own home. One judge reviewing the case apparently referred to an overzealous HOA as a banana republic.
Huh.
But it's a clear illustration of legal pluralism at work in unexpected places. This private layer of rules imposing itself quite forcefully, even in communities that might otherwise value minimal regulation. It can lead to significant personal intrusion.
Okay, so that's the private sphere. Moving back out a bit, but still local. Consider municipal regulations. Cities themselves have a huge number of their own rules, right? Ordinances and bylaws.
They absolutely do. And sometimes they create their own kind of pluralistic mess, not through conflict with higher laws, but just through the sheer volume and inconsistency of their own rules.
How so?
Well, Mariana Valverde's research on Toronto's municipal regulations is a great example. She looked at rules covering everything from street food vendors to taxis to panhandling or begging on the street.
Okay, everyday city life stuff.
Exactly. And she found this incredibly complex web of regulations, often based on very different, sometimes conflicting underlying values, public order, health, aesthetics, helping the poor, enabling commerce.
All mixed together.
All mixed together. And because of this, the regulations frequently conflicted with each other or had unintended, sometimes counterproductive results.
Can you give an example?
Yes. One observation was about taxi license renewal tribunals. Valverde noted that a certain kind of demeanor, what she called an Anglo-Christian ethic of remorse, was often rewarded when drivers were appealing violations.
Okay.
But more emotional displays, particularly by some African immigrant drivers, were sometimes misinterpreted by the tribunal members as attempts at manipulation, undermining their case.
Wow. So the cultural assumptions built into the process contradicted the city's stated commitments to diversity.
Precisely. It led to what Valverde described as an irrational and chaotic system that could be grossly unfair, despite potentially good intentions behind individual rules. It's pluralism arising from the internal contradictions of a single jurisdictional level.
Okay. And then taking the biggest step out, we get to laws that transcend national borders, what you called supranational jurisdictions earlier.
Exactly. This is the outermost ring, you could say. The European Union is a prime example.
Right. Setting rules for 28 member states.
Enacting broad policies that apply across all those countries. And these can be highly controversial, especially when they bump up against cherished local customs or traditions.
Like what?
Well, the sources highlight EU regulations that targeted things like raw milk cheeses and other artisanal foods, often for safety or standardization reasons.
Ah, the cheese example.
Yes, specifically a 2004 EU order that banned the use of methyl bromide.
Which is crucial for.
Crucial for making traditional English cloth-bound cheddar cheese. It sparked this huge controversy.
Not just about cheese, I assume.
No, exactly. It became a flashpoint about national sovereignty, about local traditions being threatened by these bureaucratic rules imposed from Brussels, from afar. It's a classic example of global policy meeting and clashing with local practice.
Okay. And beyond the EU, there's globalization and trade rules.
Definitely. International regulatory bodies like the World Trade Organization, the WTO, play a huge role. They set parameters for trade among their, I think it's 151 members now.
Yeah.
And they hear disputes.
Disputes about what, typically?
Often complaints about dumping, selling goods in a foreign market below their cost of production or home market price. The sources mention examples like Argentina complaining about ceramic tiles from Italy, or Mexico complaining about U.S. high-fructose corn syrup being dumped.
Right. Does the WTO actually enforce its decisions?
Well, its enforcement is often described as quasi-binding. It has mechanisms, but compliance can be inconsistent. Decisions can sometimes feel largely symbolic, but they still exert significant influence on trade policy and international relations. It's another layer of law-like rules shaping global economics.
And international human rights law also operates at this level, right? Trying to shape how countries treat their own citizens.
Absolutely. A key example is the UN Convention on the Elimination of All Forms of Discrimination Against Women, often called CEDAW.
Signed by almost everyone.
Over 188 countries have signed on. And it implicitly prohibits practices like, for instance, female genital cutting or FGC. Now, CEDAW itself might not have direct enforcement teeth everywhere, but resolutions and advocacy from related bodies like the WHO, UNICEF, and countless NGOs, non-governmental organizations, often act as soft law.
Soft law, meaning?
I mean, norms and standards that aren't strictly legally binding in the way a domestic statute is, but they carry significant moral and political weight. They influence local discourse, shape national policies, and sometimes exert pressure through funding or diplomatic channels. It's this very complex, multi-level engagement involving international institutions, NGOs, national states, and local officials all interacting.
But what's fascinating here, as the sources point out, is that this isn't just about, good intentions flowing down from the UN and changing things on the ground, is it? It's more complicated.
It's far more complicated, as one scholar, Sally Mary, explored in her work on human rights and gender violence. While these international human rights demands are often crucial for protecting vulnerable groups like women, they can also, sometimes unintentionally, end up buttressing the power of the state, even sometimes undemocratic states, because the state becomes the entity responsible for implementing, or appearing to implement, these norms.
Oh, so it can be a double-edged sword.
It can be. It highlights how these supranational legal norms really need to be carefully nested in and contoured to specific local contexts and power dynamics to be truly effective and equitable, not just instruments of state power.
Okay. And another perspective mentioned is this idea of globalized localism and localized globalisms. Can you unpack that a bit?
Sure. This comes from Boaventura de Sousa Santos. Globalized localisms refers to the phenomenon where specific local ideas or practices originating usually in the West, think Western human rights concepts, the English language, U.S. patent law, maybe even fast food chains get exported and spread globally, often presented as universal.
Right, things going from the local West to the global stage.
Exactly. And localized globalisms, conversely, is about how local life, local realities around the world, are increasingly shaped and transformed by these global processes. Think the impact of international free trade agreements on farmers in developing countries, or structural adjustment programs imposed by international financial institutions, or how local legal systems have to adapt to global business imperatives.
And this flow isn't equal, I gather.
No, it's highly asymmetrical. Affluent countries tend to be the exporters of these globalized localisms, while poorer countries are often the ones most subject to the pressures of localized globalisms.
And this creates conflict.
Absolutely. De Sousa Santos argues this asymmetrical distribution creates and exacerbates all sorts of conflicts, conflicts between nations, gender conflicts, ethnic, religious, even generational conflicts, as global norms clash with local traditions and economies.
Wow. And sometimes these global regimes even conflict with each other, right? It's not just global versus local.
Exactly. That's another layer of complexity. Trade agreements, like those policed by the WTO, can find themselves directly at odds with international environmental agreements, like the Kyoto Protocol on climate change.
How so?
Well, for example, industries in EU countries that were trying to follow the Kyoto standards for reducing emissions might find themselves at a competitive disadvantage against industries in countries that didn't sign or ratify Kyoto, like the US at the time.
Right, because the EU companies have higher costs.
Precisely. And proposed solutions, like a border tax adjustment, where imports from non-compliant countries would be taxed based on their carbon footprint.
That sounds logical.
It might sound logical from an environmental perspective, but it could easily be challenged as violating WTO free trade laws against discriminatory tariffs.
So one international agreement clashes with another.
Creating these policy impasses, these situations where governments are caught between conflicting international legal obligations, potentially jeopardizing the credibility and effectiveness of both regimes, it's a constant, complex dance between different global priorities and legal orders.
Okay, this is incredibly complex. Let's take a deep dive into history now. The sources talk quite a bit about how legal pluralism played out in colonial and post-colonial contexts. This seems like a really core area where different legal systems were forced together.
It absolutely is. It's fundamental to understanding modern legal pluralism in many parts of the world. Essentially, European legal systems, British common law, Dutch Roman law, French civil code, etc., were grafted onto existing local realities, local customs, local power structures in colonized territories across Africa, Asia, the Americas.
Grafted on top, not replacing necessarily.
Often grafted on top or alongside, creating these deeply plural and multi-layered normative systems right from the start. South Africa is a prime example discussed in the sources.
Okay, what happened there?
You had this incredible patchwork. First, various indigenous tribal laws and customs. Then the Dutch introduced their Roman Dutch civil law system. Then the British arrived and largely replaced that with English common law, including things like the jury system.
Okay, layer upon layer.
Exactly. And then later, under the Afrikaner National Party during apartheid, there was a partial reversion to some civil law aspects, like getting rid of juries in most cases, because they were seen as potentially unreliable from the state's perspective.
Wow.
And alongside all this official state-imposed law, you had alternative systems of what's sometimes called popular justice operating, particularly in the segregated black townships, things like informal tribal courts, but also sometimes quite violent community enforcement mechanisms. Multiple legal orders operating simultaneously, shaped by colonization and resistance.
So these weren't just parallel systems existing independently. The sources suggest they were fundamentally linked, right? Evolving together dialectically.
Absolutely. That's a crucial point. The imposition of European law wasn't just a one-way street. For instance, in South Africa, the very process of colonization and the imposition of a unified, though discriminatory, state law helped, paradoxically, to forge a distinctive, unified black identity that hadn't existed in the same way before. This new identity then fueled the anti-apartheid movement.
So the imposed law created the conditions for resistance against it.
In part, yes. And Western legal codes themselves, by providing a formal, written counterpoint to the diverse, often unwritten tribal traditions, actually helped create an indigenous consciousness of law and custom as distinct categories where perhaps that clear distinction hadn't existed before. The imposition of one system helped solidify the identity of the other.
That's fascinating, and this often led to indigenous people finding ways to use the imposed legal systems to their own advantage. The sources call it law as a weapon of the weak.
Precisely. People who are subjected to a dominant legal system aren't always just passive victims. They often find ways to navigate, manipulate, or harness aspects of that imposed system to resist domination or advance their own interests.
Can you give some examples?
Sure. The sources mention historical examples like Native Hawaiian women using newly introduced colonial laws and courts to contest patriarchal violence within their own communities, or enslaved people in the British West Indies, finding small legal avenues to resist their condition. or even women in 16th century Istanbul using the Ottoman court system to challenge aspects of their subordination, pushing back against customary gender practices through the formal legal system.
So this is a really powerful reversal, isn't it? Using the master's tools, so to speak, against the master, or at least to carve out space within the master system.
Exactly. Shelley Gavigan's work, mentioned in the sources, showed how First Nations people on the Canadian plains in the 19th century, even as they were being criminalized by new colonial laws against horse theft, for instance, which targeted key aspects of their economy and culture, they simultaneously learned to skillfully use the new colonial courts to extract benefits, settle disputes among themselves in ways recognized by the state, and generally advance their interests where possible. It's strategic adaptation.
And we see this happening even today.
Yes, absolutely. Contemporary examples include Indigenous peoples in places like New Zealand and Vanuatu who are adapting Western legal concepts like copyright and trademark law.
Wow.
They're using these tools, originally designed for commercial purposes, to try and protect their traditional knowledge, their cultural artifacts, their collective identity, essentially, to shore up local sovereignty and self-determination using the language of international intellectual property law. It's termed Indigenous intervention, actively reshaping global legal tools for local Indigenous goals.
That's really interesting. And the influence wasn't just one way, from colonizer to colonized, right? The sources mention reciprocal influence, too.
That's another important dimension, yes. The influence sometimes flowed back, or perhaps emerged from the interaction. A key example discussed is alternative dispute resolution, or ADR, in the United States.
Things like mediation and arbitration.
Exactly. These methods, which emphasize negotiation and compromise outside of formal court proceedings, have roots, at least in part, in the informal justice systems practiced in places like rural Mexico and China systems, often encountered or studied by Westerners in colonial or postcolonial contexts.
So ideas flowed back.
Ideas flowed back, or at least resonated. Mediation, in particular, gained huge popularity in the U.S. from the 1970s onward, partly driven by concerns about rising court costs and delays, the very dysfunctions we discussed earlier. But it was also lauded for offering more emotionally satisfying, less adversarial solutions, drawing implicitly on these non-Western traditions of dispute handling. It shows a kind of cross-cultural legal fertilization happening over time.
Okay, so bringing all these threads together, what does this all mean for how we understand law itself? It's clearly far more complex, far more layered and dynamic than we might initially think.
It absolutely is. One scholar, Eve Darian-Smith, whose work Law and Societies in Global Contexts is mentioned, tries to integrate all these dimensions. She talks about the myriad levels of law operating just in one physical location, from formal state law down to, popular culture artifacts, like maybe even the conflicting messages in advertising.
Right.
And connecting that local complexity to the multitude of interconnected global legal regimes, trade, human rights, environmental law, all swirling around.
It sounds almost overwhelming.
It can be. And her perspective argues that while law is always inherently multifarious, plural, certain versions, usually elite Euro-American state-based versions, often achieve hegemony.
Hegemony meaning dominance.
Dominance, yes. One powerful legal system or perspective comes to overshadow and influence others, often silencing or marginalizing alternative legal views or systems.
But recognizing this pluralism, this complexity, is important.
Crucially important, she argues, because recognizing the inherent plurality in the power dynamics involved opens up spaces for local resistance, for challenging that hegemony, and for what she calls counter-hegemonic. Studies efforts to understand and support those alternative or suppressed legal orders.
Now, there's an ongoing debate, isn't there, mentioned in the sources, about whether the term legal pluralism itself is maybe too broad, too imprecise.
Yes, that's a fair critique. Some scholars worry it lumps too many different things together: nested federalism, administrative discretion, colonial encounters, global treaties potentially obscuring important distinctions between, say, global transnational and international legal regimes.
And also, maybe that scholars studying legal pluralism sometimes seem biased against formal hierarchical state law.
That criticism exists too, yes. That there's sometimes a romanticization of informal or non-state justice. But others have tried to bring more structure to the field. Boaventura de Sousa Santos, whom we mentioned earlier, attempted to systematize it by identifying 6 broad clusters or types of law he saw operating in contemporary capitalist societies.
6 clusters. What are they?
He listed domestic law within the household, production law in the workplace, exchange law in the marketplace, community law, local norms and associations, State law, the official legal system, and systemic law, global or transnational regimes.
Okay, that's a comprehensive list.
It is. And the key point is that these clusters are rarely independent. They constantly bleed into each other, they intersect, they sometimes conflict directly, or sometimes they're neatly nested within each other, like state and federal law often are. It's a map of the complexity.
And when conflicts do arise between these different levels or clusters, that creates openings for change.
Exactly. Social movement actors, activists, reformers, they can strategically play one level off against the other.
How does that work?
Think about South Africa's transition from apartheid to democracy, as analyzed by Heinz Klug. The architects of the new constitution very deliberately adopted a strong Bill of Rights and gave the courts broad powers of judicial review.
Right.
They were strategically borrowing and creatively reinterpreting foreign legal concepts from Germany, Canada, India, the US, and embedding them in their new state law precisely to manage and, as Klug puts it, civilize potentially unnegotiable political conflicts that were simmering at the community and political levels. They used one level of law, constitutional state, informed by another, international systemic, to reshape others, community political.
That's a very conscious use of legal pluralism for social transformation.
A very conscious and quite successful example. Another powerful global example is the movement for the abolition of the death penalty.
We touched on the U.S. situation, but globally.
Globally, the trend is dramatic. When the UN adopted the Universal Declaration of Human Rights in 1948, with its core principle of the right to life, most countries in the world still had the death penalty.
Okay.
But by 1976, the number of abolitionist nations had risen significantly. Today, a large majority of countries no longer impose it in law or practice.
And international human rights discourse played a big role.
Johnson and Zimmering, whose work we discussed earlier on the U.S., argue strongly that yes, the development and spread of international human rights norms had a substantial impact globally. It created a new normative standard at the systemic level that abolitionist movements could use to pressure states at the national level.
But it's not automatic, right? Local factors still matter hugely.
Absolutely. Local culture, tradition, religious views, and crucially, the nature of the political regime, for instance. Authoritarian versus less authoritarian states, particularly in Asia, still heavily influence whether and how the death penalty is actually implemented, even if a country has signed relevant treaties.
So it's an interaction between the global norm and local realities?
Exactly. But the global trend offers hope, suggesting that what Johnson and Zimmering call the malleable element of state power, the fact that state policies can change in response to these plural pressures, could eventually lead to worldwide abolition. We've even seen significant drops in executions in places like China over the last few decades, suggesting change is possible even in complex political contexts.
Okay, so what's truly fascinating here, when you pull back, is just the sheer multiplicity of these normative orders.
Right.
Formal laws, informal customs, rules from the top down, pressures from the bottom up. It really makes you wonder, is law even a single, unified concept anymore? Or is it just a convenient label we stick on vastly different kinds of social phenomena?
That's really the fundamental question legal pluralism forces us to confront. And there's definitely debate, as we noted, on whether things like uncodified community norms or non-state systems should technically be called law.
Right.
But the deep historical crossbreeding we see, especially in colonial and postcolonial contexts, where state law and indigenous systems profoundly shaped each other, suggests that maybe, despite their differences in form or source, they are, in a sense, of the same species. They're all systems attempting to regulate human behavior and order social life.
Mm-hmm.
Ultimately, what legal pluralism undeniably shows us is that multiple legal and normative systems are always operating simultaneously everywhere. Sometimes they function like a division of labor, like idealized U.S. federalism. Sometimes they overlap without much conflict, like maybe private security guards and local police patrolling the same area.
Right.
Sometimes there are gaps between them, leading to accountability failures, like the Blackwater example. Sometimes there's this rich cross-fertilization, like we saw with colonial post-colonial systems or ADR. And sometimes they're on direct collision courses, like international human rights conventions versus deeply ingrained local traditions, or federal versus state drug law.
And when those systems do collide.
When they collide, one may effectively be nullified, if not officially abolished, then at least in everyday practice. Just like those conflicting signs at the gym entrance. The lived reality on the ground determines which rule actually governs behavior.
So what we've really discovered in this deep dive is that legal pluralism isn't just some abstract concept for law professors or anthropologists.
Not at all.
It's the dynamic, often really messy reality of how rules, norms, and power actually operate in our world. From a sign at a gym entrance all the way up to international human rights treaties. It seems fundamental to how societies function, how conflicts arise, and how justice is sought. Or sometimes how it's evaded.
And it really underscores that laws aren't these static, fixed entities handed down from on high. They're more like alchemical partners with society, as one source put it.
Alchemical partners. I like
Yeah,
that.
meaning they're constantly shaping society, but also constantly being reshaped by local realities, by global forces, by human agency, often in really unexpected, almost magical, or at least unpredictable ways. Understanding these many orders allows you to see the intricate connections, the hidden influences that are always at play, often just beneath the surface.
So the next time you encounter a seemingly small inconsistency in rules, maybe like those gym signs, or you hear about a big global trade dispute or a conflict over a local versus national policy, maybe take a second to consider the many laws, many orders that might be interacting there. How might you navigate or maybe even influence this intricate web in your own life or your own community? What unseen legal layers might be shaping your day?
That's a key takeaway. It's everywhere.
It really is. Thank you for joining us on this deep dive into the fascinating world of legal pluralism.